Hey everyone! Today we are heading over to the great state of Kansas for a nasty custody hearing. I saw that there was an update to this video, so I went to work getting the update, and I inadvertently stumbled across two prior videos that I didn't know existed and should have had before this point in time. So the update will come at the end, but first, how about a little pre-quill? I'm not able to see any of the case history on this one. You can't access files from family court cases in Kansas. But from what I can gather, there was a court order prior to this hearing ordering both parents to go obtain a hair follicle test. This case is very contentious. So let's get to it. Oh, and to help you keep track of your place, like what hearing we're on, in addition to chapters, just follow the bouncing penny.
Kansas case is entitled The Matter of the Paternity of BBK by and through Natural Mother and Next Friend Deambra Rickey versus Grant Coker, case number 22 DM 371. Would counsel announce appearances, please?
May it please the court, Rebecca Henry appearing on behalf of Deambra Rickey, who also appears via Zoom.
Good morning. May it please the court, Eric Kidwell appears on behalf of Grant Coker, who also appears on this Zoom recorded hearing.
Thank you, counsel. We were last here July 7th, at which time the court had made some modifications to Mr. Coker's parenting time due to needing to provide some documentation on hair follicle testing, interlock paperwork. We set a status hearing for today. Counsel, what is the status of the case at this point? Ms. Henry, I'll address you first.
Yes, Judge. No documentation has been provided for the hair follicle test. I reached out to Christina Retzlaff, who is the domestic conciliator, to ask about the status of DC. She indicated to me that she's not heard from Mr. Coker, which would be contrary to what Mr. Coker had indicated at the last hearing, where he had set up some sort of payment plan with her and was planning to make payment. As far as she's reported to me, Mr. Coker has made no payment to her, and there has been no partial payment. So I do not believe that Mr. Coker was truthful to this court about that. I also don't have anything for a hair follicle test. As this court may recall, Mr. Coker had indicated he had submitted to some sort of test on Rock Road hair testing or a drug testing facility. When we inquired, they didn't have any record of him. And then there's been no hair follicle test that has been received since that time. So I don't believe Mr. Coker was truthful with this court about that. I received just a minute or two before this hearing a documentation from Mr. Kidwell's office as it relates to the interlock device. I would note to the court, this is not the information that we requested from Mr. Coker. It shows an initial interlock install in April of 2023, and then there's some additional documentation from May. Our concern at the last hearing was that he had purchased a new vehicle after May and did not install the interlock device into that vehicle. Based on the information that's provided, it would appear that that is still the case. There is no documentation that has been provided for Mr. Coker that indicates that he has installed the interlock device in his new vehicle. So I still don't have that information that we've requested. Your Honor, you had indicated at the last hearing, if he fails to provide this documentation, his parenting time is reduced to Saturdays from 8 to 8. There has also been no child support that has been paid. And this is an issue that I wanted to bring up for the court. And I apologize, Judge, I'm just going to kind of go through my punch list, if that's okay with Your Honor. I issued an income withholding order earlier this year because this court did order Mr. Coker to pay child support in 2022. I was contacted by Folston Siefkin after the last hearing because Mr. Coker has raised a legal issue with his employer about whether or not they can withhold wages, seeing as he's a subcontractor. So now his employer has had to engage in litigation services with Folston Siefkin to address Mr. Coker's concern. All the while, he has not paid 1 penny of child support to my client. Apparently, it is quite obvious that Mr. Coker doesn't believe the rules apply to him in this court. If he is this blatantly defiant of court orders, what's being done behind closed doors would be my question to the court. There are allegations he's made threats to kill my client, that he's called her a fat cow in front of the child. I think the court should assume that he has a positive hair follicle test at this point and is an active drug user because of his blatant failure to submit to a hair follicle test and produce that for this court for almost a year now. He's lied to this court about his communications with the domestic conciliator. He's lied to this court about his submission of a hair follicle test. He has not been truthful about the interlock device. My client would state that he is still driving Beckett around in a vehicle that we don't have any documentation has an interlock device installed in it.
Okay, let me give you a little background on why she might be so concerned. Let's take a look at Dad's track record, just from what I could find in the surrounding areas in Kansas. So it started in 2005 when he was 20 and was charged with purchase of alcohol by a minor and refusal to submit to a breath test. Then we moved on to 2009 and there was a driving under the influence and a forcible detainer. 2010, a driving without a license and a DV. 2011, another driving under the influence and without a license, and then a pedestrian under the influence charge, which I had never heard of before. I mean, I know you can get it in a boat, and then there was the whole, Bill Murray in the golf cart, but now you walking? Awesome. 2012, another driving without a license. 2016, the gas company sued him. 2018, the urologist sued him. 2019, he had a legal battle with his employer. Then again in 2019, he had a tax warrant. 2020, another driving without a license. 2022, there was a legal action against him for not paying a credit card, which brings us to 2024. And the attorney from this case is suing him to recover the $57,000+ that he owes him. I'm not trying to judge him. I personally live on a perpetual roller coaster. However, Dad's hard times started when he was 20 and have lasted almost 20 years. I think we can safely say Dad doesn't have his shit together, which probably does not make for a great environment to raise a child. So I understand Mom's concern in this regard.
And so I think he's just thumbing his nose at this court. So for that reason, we're asking previously that his parenting time be reduced. That was our original proposed parenting plan back in July. We are renewing that request that his time be reduced even further. At a minimum, we're asking that it be reduced every other Saturday from noon to 8. Our original proposal was that it be supervised at VEP for 4 hours at Dad's expense. So if the court wants to order that, up to every other Saturday from noon to 8. I mean, we just don't believe that he is entitled to any additional parenting time, that it's in the best interest of Beckett to be around him for any additional parenting time, certainly no overnights, and that he should not be driving with Beckett at all, because he has not produced any sort of documentation that would support that he is complying with other court orders as far as his interlock device. There is also an upcoming event on September 1st and 2nd. Mr. Coker has asked to take Beckett to a Red Sox game in Kansas City for his birthday. My client acknowledges that Beckett has been looking forward to this for some time. And in the best interest of Beckett, she doesn't want to prohibit him from being able to attend that, but she does not want Mr. Coker to transport him. So my client is willing to transport Beckett to Kansas City to attend the game, and then we'll pick him up after the game and drive him back home. And that should be Mr. Coker's parenting time for that weekend. I am also requesting fees at this point. We have had continuous review hearings for Mr. Coker's failure to comply with court orders. My client has incurred fees for preparation of those hearings, attendance of those hearings, and follow-up afterwards. We have had the last hearing because he didn't comply. We had this hearing to give him an opportunity to comply. And then we will inevitably have another hearing because Ms. Retzlaff indicates that she will have the DC recommendation next week. So given the cost that we have already incurred and future litigation costs, and court costs that we anticipate having as a result of Mr. Coker's failure to comply with these court orders, we believe warrants an award of a prepayment of attorney's fees in the amount of $1,000 to my trust account. And Mr. Coker, I would like the court to note, Mr. Coker is audibly laughing. I know that he's on mute, but as I'm making this argument, I can see Mr. Coker's face and he's laughing at what I'm arguing. So again, his thumbing his nose at this court and my argument and his blatant disrespect for the rules and what this court has ordered is apparent. And it's insulting to this court, to myself. It's not in the best interest of Beckett. He has not done anything that this court has asked for. And we did not have time to prepare a contempt prior to this hearing date, but Mr. Coker should expect that forthcoming because he has not done anything to show this court that he gives an iota of concern about his child. There are serious allegations that have been made against him, and he laughs in the face of those requests and fails to comply for anything. And so at this point, we continue to have significant safety concerns about Beckett while in Mr. Coker's care. And again, I would inquire to this court, if this is what he is doing so blatantly out and about, I can only imagine what is happening when we are not out in public, when we are behind closed doors, and what is being said. Thank you.
Thank you, Ms. Henry. Mr. Kidwell, your response?
Thank you, Your Honor. The information that we received at 9:39 a.m. Regarding the vehicle, it was installed 4/18 on a 2001 Chevy Silverado, and the second piece of paper is confirmation of that, and it's on the same vehicle, and that's from the state of Kansas. So the reason I'm advising the court of that is that I believe that this is proof that that's not only did Smart Start install it, but the state verified it. And it also states on the piece of paper when he was supposed to bring it back in to check, there was an appointment in May. So to my knowledge, obviously this 2001 Chevy Silverado, and he's taken it back to Smart. It's the same vehicle. So I believe that of the list that was provided by Ms. Henry, that has been provided. I have not received hair follicle results. My staff contacted after the last hearing, Ms. Retzlaff's staff, and they advised that my client had contacted them and made payment arrangements, but I have not talked to them since we were here last. I do not have, as I stated, I don't have hair follicle information. All I have is the proof from the state and from Smart Start that there is an ignition interlock. I know that the income withholding order was being enforced. I was contacted by counsel for the corporation that Mr. Coker works for, and they had talked to the corporation, and the corporation said, yes, that's correct. So that income withholding order, my assumption, that was, I think, Wednesday. So I talked to Holly Dyer, and they went ahead and put the income withholding order in through his employer. As for the allegations of things that were said, allegedly said by my client, we talked about that obviously at the last hearing, and I don't have any information as to when and where these statements allegedly occurred, so I could obviously respond accordingly. I would like for Beckett to be able to go to the game, and if the court determines that Miss Ricky will drive the child up and bring the child back from the Kansas City baseball game, my only question is, and I will gladly do this for the court, if Miss Henry and the court ask, with these two pieces of paper, I can actually go and look inside the vehicle and see if the thing's working and make my client blow into it to see if it's working. But all this says is that he had it installed and he went back in May and it says check. So they check to make sure you haven't been driving, as you know, Your Honor, or attempted to operate the vehicle with alcohol.
Mr.
Austin.
Kidwell, it's been alleged that a new vehicle was purchased after May by Mr. Coker. Your response?
All I have is what was sent to my office, Your Honor, this morning at 9:39. And I'm assuming that this would be on a vehicle, meaning a new vehicle. But I don't have any other paperwork. And
I
that's
think what Miss Henry alleged is that since the initial interlock was installed on that vehicle, that a different vehicle has been purchased or is being driven by Mr. Coker. Do you have any information in response to that allegation?
No, I don't. But if Mr. Coker would like to drive that vehicle to my office, I certainly know from all the criminal work that I do, Your Honor, how it works and what it's supposed to sound like, and it should be on the vehicle that he stated to the court is the vehicle he's driving. That has been his statement.
Miss Henry, did I properly identify what your allegation was in that regard?
Yes, Your Honor.
Okay. All right, go ahead, Mr. Kidwell.
I understand that Ms. Henry stated that she'll be filing a contempt, and that she is seeking $1,000 in fees. Obviously, that is the court's decision solely as for how that goes. In the contempt, I know that because we plead with such specificity, I can properly respond. So I would only ask that the issue of attorney's fees be held until we have the contempt hearing. But going back to that vehicle, as I said, if the court would like, I'm an officer of the court. If he drives a vehicle here, we can take a picture of the VIN number and a picture of the ignition interlock and the vehicle itself, and I can send those to Miss Henry. But as I stated, the only thing I have was what was received at 9:39.
All right, anything further, Mr. Kidwell?
No, I just confirming that I do not have a hair follicle. When my staff contacted Miss Retzlaff, my office manager talked to one of her assistants. They stated that he had started a payment plan, so we have not called back. But I think the child support order, now that the income withholding order was actually filed with the corporation through outside counsel, as I stated, Miss Dyer contacted me. So that obviously is being withheld. I don't know when that first payment will show up, but that was, I'm guessing it was Tuesday or Wednesday I spoke to Miss Dyer, Holly Dyer. So I'm still waiting for a hair follicle, and obviously we can recontact Miss Retzlaff. But the issue of the child support not being paid has been corrected because they did issue that income withholding order that you ordered last year.
All right, thank you, Mr. Kidwell.
Thank you.
I'm looking back through my docket notes. And I don't know if this is the first time that I ordered it, but back on November 14th, 2022, at that time, each party was ordered to do a hair follicle test. We still don't have a hair follicle test from your client, Mr. Kidwell.
That's correct.
And the only assumption that the court can make by someone refusing to provide a hair follicle test is that it's going to be dirty. We've had a number of excuses. Oh, I didn't have a driver's license, so I could go get it. We don't have any child support paid. We've had an income withholding order on file. Mr. Coker's been advised that if a income withholding order is not paying out, that it's his responsibility to make the child support obligation. That hasn't been done. We don't have a domestic conciliation report or any proof that payments have been made by him towards that. Mr. Coker's doing absolutely nothing to further his position in this case. It's baffling to me. Because Mr. Coker, in this court's mind, is using illegal drugs and or alcohol, I'm going to modify his parenting time to every other Saturday, supervised with VEP for up to 4 hours. The first Saturday can be this Saturday, tomorrow. Regarding the Red Sox game, I'm going to adopt the recommendation from Miss Henry that Miss Ricky transport Beckett to the game and drive him back after the game. Mr. Kidwell, you've offered to have Mr. Coker drive the vehicle to your office. Frankly, I would appreciate if he would do that. I have no confidence that he will actually follow through and do that, because he's followed through on absolutely nothing up to this point that's been asked of him to do. But if you can do that and provide the information to the court would take that into further consideration down the road. Regarding attorney's fees, I'm not going to order those at this point, though I will reconsider that down the road. I'm not going to set a further hearing at this point. If domestic conciliation recommendations are made, you all can follow the appropriate local rule regarding either adopting those or by agreement or scheduling a hearing if there's objections. If Ms. Henry, you do file a contempt motion, we can get a date to take that up, but I'm not inclined to set another date because frankly, we're not accomplishing anything each time we show up. So,
Your Honor, would it, as I explained, I could do that because I've had to do it in other municipal and state courts. And what I normally do is take a picture of the VIN through the windshield or on the door. And then I take a picture of the device and then I have my client start the vehicle and I take a picture of the vehicle running with the device after they blow in it.
that would certainly, if that's able to be accomplished.
I can
would
do
reach the
that whenever
court's
he can bring it
concern
by.
regarding that issue. But again, that's not going to alter the order that's been made here today.
I understand, Your Honor. I just wanted to be specific because I've had to do it before for over the years for different clients.
Very well. Ms. Henry, anything further or need clarifications from your end?
Two questions, Your Honor. The first, I just want to make sure the record is clear. We acknowledge that he has a Chevy Silverado that likely has an airlock device in it. The concern is that he has purchased an almost exact, he's purchased another Chevy Silverado, so same type of vehicle, but that vehicle does not have an airlock device in it. So while I appreciate Mr. Kidwell's offer, and certainly if he wants to do that, that's fine, but we're not disputing that there is a vehicle with an interlock device in it. The concern is there is an additional vehicle that Mr. Coker has been transporting the child in after May that does not have an interlock device in it. So if Mr. Coker brings one vehicle to Mr. Kidwell's office to verify that's an interlock device, unfortunately, that's not going to alleviate the concern we have that there is another vehicle out there, same make and model, that Mr. Coker has purchased and is transporting the child with that does not have an interlock device in it. So that was one thing I wanted to make clear. The second is I would ask that the VEP be at Mr. Coker's expense, especially since he is so far behind in child support. And my client, honestly, we just don't have the additional funds to pay for supervised visits. And this is all because of Mr. Coker's failure to comply with court orders. So we believe the onus should be on him to be responsible for that financial burden.
That will be the order of the court.
Thank you.
All right, anything further, Mr. Kidwell?
No, Your Honor.
All right, Ms. Henry, can I task you with preparing a journal entry reflecting the orders the court has made here today?
Yes.
All right. If there's nothing further, we'll be in recess. Thank you.
Thank
you. Good morning.
Good morning, Judge.
Rebecca, have you heard anything from Deb Thompson this morning?
I did. She sent over a settlement offer just a few moments ago. And I don't know. She called my office to ask if we were going to be there in person. I don't know, maybe she didn't get the email about it being transitioned to Zoom. So I don't know if she's there at the courthouse or not. Has Angela seen her, or do you know if she might be there in a courtroom somewhere?
Angela, can you check with security to see if she's coming in?
I'm checking now, Judge.
Okay.
And she's been emailing me. She just emailed me.
Judge, they don't have anybody here at the courthouse.
Okay.
Okay. Yeah, she's emailing me, and we have an agreement, I think. And I would like her here just to make sure that I have it read into the record correctly.
Okay.
Do you want me
Why
to
don't
try?
I'll go off camera and we'll see if we can't track her down.
Okay,
All right, I see Miss Christina Retzlaff, you're here.
Right. Is there any need for me at this point if there's an agreement?
Well, that's what I was gonna check and see.
yeah, I don't think so, but I don't, I thought that Deborah was gonna get on the call this morning, so I don't think that you're needed, Christina, for what it's worth.
All right, I'll tell you what, if it turns out there's not an agreement and you're gonna need to appear at some point, we'll just notify you.
That's fine. I'll be here all morning. Thank you.
Okay, thank you.
Thanks, Christina.
All right, we'll see if we can't track Deb down and we'll come back on here shortly, hopefully.
Okay, thank you, Judge.
Morning, Deborah.
Good morning, Your Honor. I had gotten an email from Ms. Henry, and so I thought I should probably go ahead and log in, just make sure we were all on the same page here.
Okay. Is your client going to be on here or not?
No, he's not, Your Honor.
Okay. All right, we'll go ahead and go on the record. This is in the District Court of Butler County, Kansas. Case is entitled "The Matter of the Paternity of BBK, Minor Child by and through Natural Mother and Next Friend, Deambra Rickey versus Grant Coker." It's case number 22 DM 371. Would counsel announce appearances, please?
May it please the court, Rebecca Henry appearing on behalf of the petitioner, Deambra Rickey, who also appears via Zoom separately.
Deborah Thompson appearing on behalf of the respondent, Grant Coker.
All right, thank you, counsel. This hearing was set originally as a hearing to review the domestic conciliator's recommendations. I don't particularly know how to describe all of the exchanges of emails and the current circumstances that were going on with the case, but we set it today more or less as a status or a request to continue the motion to review. It's my understanding that the parties perhaps have reached some sort of a agreement or settlement of the pending issues. Is that correct, counsel?
Yes, Judge.
I believe so.
All right, and are you wanting to state what agreement's been reached here on the record?
Yes, Judge, I'd like to state it on the record just so we have it, and then we can submit an order Rule 170 reflecting that agreement.
Okay, go ahead, Ms. Henry.
Judge, the order with regard to the parenting time issues, there was a DC recommendation that was filed by Christina Retzlaff. It was submitted pursuant to Rule 16 on February 13th of 2024. Parties are in agreement to adopt that recommendation in its entirety and have agreed to subsequently make one slight modification or addition, I guess, which would be that if the respondent does not complete all of the recommendations, which I think for him begin on page 11, well, I guess page 10 of the recommendation, within 10 days of this order, then his parenting time shall revert back to the current order, which is 4 hours of supervised time each week at VEP. And the cost for that is attributed to the respondent.
All right, Ms. Thompson, is that your understanding of the agreement that's been reached?
Yes, Your Honor.
All right, are there any other provisions other than what's been announced?
Judge, not as it relates to child support or as it relates to parenting time. I do have a question for the court about child support, but once the court, I guess, rules on this particular issue, I'll make that request.
Okay. Well, the court will adopt the agreement that's been reached as a final order as it relates to the parenting time.
Thank you, Judge. And I'm happy to draft that
Okay.
with a Rule 170 and send to Ms. Thompson.
Very well.
Judge, my question about child support, in our original petition, which was filed almost 2 years ago now, my client made a request for support back to birth. The court had temporarily set child support starting October 1 of 2022. And I believe that the respondent has a pretty significant arrearage, even dating back to October. But didn't know, as far as the request for child support dating back to birth, if we could take that up, if the court would entertain that request, if the court typically does grant back to birth if requested. And then if not, we just need to include an arrearage amount as a judgment in the final order from at least October.
All right, Ms. Thompson, what's your position on that request?
Well, not having been able to really speak with my client about that, I don't want to agree to anything that I don't have authorization to from him. So I guess I'd prefer to set the child support matter specifically over to another hearing date, just so that the court can take it up in full and be fully advised by both parties at that time.
And Ms. Henry, there's a temporary or a child support order already in place, correct?
Correct, yes. And as this court may recall, there were some issues with getting the income withholding order filed. And so the respondent went several months, even though the court made the order effective October 1, with getting child support. So I think that we are behind significantly because the income withholding order didn't come out until this year. And he had support starting October of 2022.
Well, I'm certainly willing to address that, and I want to get that issue resolved. I don't know if that's something that we're in a position to take up right now. Do you recall when that request was originally made, Ms. Henry?
So, Judge, our original petition, which included the request for support dating back to birth, was filed in September of 2022, September 8th.
Okay.
The order for temporary child support, I think was originally ordered back in December of 2022. We had an order, and the child support obligation was effective October 1. The respondent hadn't submitted a domestic relations affidavit yet, but the court did adopt our proposed child support worksheet at that time. So that's when the original child support order was established. And then we attempted to do an income withholding order in January of 2023. But there were multiple issues because it's an out-of-state income withholding order with getting it to pull from his paycheck. So at the very least, I think that Kansas Payment Center should have record of all of the payments that he's made, because Mr. Coker's made no direct payments, to my client. So KPC is an accurate representation of the number of payments that she's received from him. And so at a minimum, I think that Ms. Thompson and I could establish a judgment from October 1 of 2022 to present for what he owes. And then if the court wants to set over the matter of whether or not my client gets child support from birth to October of 2022, I would just ask that that be done expeditiously. And if we could do that by Zoom, that would be great, since it's just a support issue and it's just numbers. But if the court wants to do that in person, I certainly understand, appreciate that too, and we'll make that happen.
Okay. Well, let's go ahead and set that over for hearing then. Then the two of you can exchange whatever numbers you have, see if there's any chance of getting a resolution by agreement, and then if not, we can hear that. Go out about at least 30 days. Does that give everybody enough time?
It does, Judge.
Yes, Your Honor.
Okay, and I don't have a problem doing that by Zoom. Ms. Thompson, your thoughts?
Yes, I think Zoom would be preferable, Your Honor.
Okay. Angela, something around 30 days out by Zoom. Do you think we'd need more than an hour?
I don't.
I wouldn't think so.
Judge, I have May 7th at 1:15.
I'm checking now, Judge.
I am available at that time, if that works.
All right, we'll do.
Oh, sorry, Judge. I am in Cali County.
Oh, okay.
May 9th at 1:15.
I'm out of the state. Darn, anything May 8th? I'm wide open May 8th.
I have May 8th at 9 o'clock.
I could do that if that works for Ms. Thompson.
Yes, I'm available then. No
Yeah.
problem.
We'll take that child support issue up then May 8th at 9:00 a.m. By Zoom. Anything else we need to establish as far as deadlines or anything of that nature?
No, is the court okay with setting a judgment amount for what arrears dating back at least to October, so long as Ms. Thompson and I can establish what that number is?
That's fine. If you just want to
Okay.
submit it as an order, I'd sign off on it.
Okay, I will do that.
All right. Anything else we need to address this morning?
I don't believe so, Judge.
All right. And Ms.
No.
Henry, you advised you were going to journalize the agreement regarding the parenting time.
I will, Judge.
All right. Thank you, everyone. If there's nothing further, we'll be in recess. Have a Good afternoon.
Good afternoon, Judge.
All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Cases entitled in the matter of the paternity of BBK, minor child by and through natural mother and next friend, Deambra Ricky and Grant Coker. It's case number 22 DM 371. Petitioner Deambra Ricky appears with counsel Rebecca Henry. Grant Coker appears in person, pro se. I will note, Mr. Coker, you had previously been represented by Deborah Thompson, who has withdrawn from the case. I don't see an entry of appearance from anybody else. Have you hired other counsel?
No, I've not.
Okay. All right, I have this down as a hearing regarding child support dating back to birth. Are there other issues that you?
No, Judge, that we just had set that over for another date. This was originally set earlier. And as the court may recall, Ms. Thompson had indicated she had some sort of personal conflict or emergency that day. Mr. Coker did not appear at that hearing. Ms. Thompson had just emailed me to let me know that she was not going to be available. And so kind of on an emergency basis, we had moved it to today.
All right, yes, I do recall that. And are you ready to take that up?
I am, Judge.
All right, Mr. Coker, are you ready to take up the issue of child support going back to the birth of the child?
I have other things I'd like to talk to, but if we want to start with that, then yes, that would work.
Okay. Go ahead, Ms. Henry.
Thank you, Judge. And I'm not prepared to make an argument on anything else today. Nothing else is before the court. So I would object to the court hearing anything else or us making argument on anything other than what we specifically set the hearing for today. So this petition for paternity was filed on September 8th of 2022. The parties have one minor child, Beckett, who was born September 1st of 2011. My client has always maintained primary residential custody of Beckett. And in our original petition, we requested child support dating back to birth. The court had set some temporary child support along the way. As this court may recall, Mr. Coker refused to pay child support for a majority of this case, necessitating an income withholding order. And then Mr. Coker had objected to the income withholding order, retained counsel at Folston Siefkin to try and object to the income withholding order. And so my client went several months without any sort of support because Mr. Coker refused to pay it voluntarily, and then tied up the income withholding order issue in litigation for several months before eventually the income withholding order went through and my client has started to receive regular support. We did request at the time that we finalized this case for the court to hear argument on support dating back to birth. I have prepared 2 child support worksheets, which have been submitted to the court, I believe today. One that just shows what support would be using my client's current income and Mr. Coker's purported income when Beckett was in the age bracket of 0 to 5. And then again, a child support worksheet for when Beckett would be in the 6 to 11 age bracket. Beckett has recently jumped to the 12 to 18 age bracket, but the court has already established child support and an arrearage amount as of October 1st of 2022. So really, we're talking about support from date of birth to October 1st of 2022. In looking at those 2 worksheets, and again, Mr. Coker has failed to file a domestic relations affidavit. He's failed to provide me any sort of income documentation. His
Those were all
attorney
filed before with my first attorney.
Mr. Coker, you'll have an opportunity to respond.
Okay, thank you.
Ms. Thompson did not file any proposed domestic relations affidavit. I don't have any updated income information from Mr. Coker. So I am going off of what information my client's provided to me based on what information she has. And so without there being any other documentation before the court today, I think the court is bound by what we have proposed. My client has filed a domestic relations affidavit and proposed child support worksheets. So in reviewing those figures, if you look at the 4 months in 2011, because Beckett was born September 1st, so you'd be looking at September, October, November, and December. And then through 2017, when he would have jumped to the 6 to 11 age bracket, you're looking at 64 months. And the proposed child support worksheet I have based on the income information of the parties would yield a child support obligation for Mr. Coker of $959 per month. Times 64 months is $61,376. From there, Beckett jumps to the 6 to 11 age bracket in 2017. So starting in 2018, I actually gave Mr. Coker the benefit of finishing out 2017 year in the 0 to 5 age bracket. So starting in 2018, 19, 20, 21, 2018, 19, 20, 21. Plus the 9 months of 2022 before the court entered its judgment in October. That would put Mr. Coker at 57 months. And the proposed child support worksheet with Beckett in the 6 to 11 age bracket yields a $1,084 per month obligation for him during that time period, which is $61,788. With both of those combined, the total amount is $123,164 from birth to October 1st of 2022. He's provided no documentation that he has made any sort of regular support payments. There was no child support order that was done. My client's proffer to this court is that there wasn't any regular child support that was paid during that time period. She was solely financially responsible for Beckett, and that there should be a judgment entered in for that dollar amount from birth. In addition to the $11,000 the court has already ordered as a judgment from October to present, because Mr. Coker failed to pay child support even when court ordered.
All right, thank you, Ms. Henry.
Uh-huh.
Mr. Coker, I'll give you an opportunity to respond.
Thank you, Your Honor. We lived together for the first 3 years of Beckett's life, and which I took care of all the responsibilities then at that time. She failed to mention that. I did fill out the domestic relations paperwork with Eric Kidwell when he was still my attorney. If he never turned them in, I don't know. I still probably have copies of them that I sent to him via email that I can submit. And she never asked for child support in the past. In fact, she flat out refused child support in the past. And we had him 50% of the time at that time.
When you say we, who are you referring to?
Me and my wife. And it was literally split 50-50 up until 2022.
All right, anything else?
I can provide documentation proving that. I can fill out another affidavit if the court would allow it.
How come you haven't done that already? With this
I have. I
hearing
did it
set?
with Eric Kidwell.
Ms. Henry, did you receive any documents from Mr. Kidwell in that regard?
No, Judge, I'm looking at the court file that I have saved in my client's file, and there's not anything that, I mean, Mr. Kidwell filed an answer to the petition and a verified motion,
And that's probably why
but
Eric was fine.
there's no domestic relations affidavit.
I know I did submit it to him, and I'm almost positive I have it in my email. I can go back and find.
Ms. Henry, what is your response to the statement made by Mr. Coker that the parties lived together for the first 3 years of Beckett's life?
You know, I would have to talk with my client about that. I don't have any comment about that. So I don't have any specific statement without talking with my client.
Okay.
So the parties have had a sordid history with regard to custody and parenting time. And we would deny that they've been doing shared parenting time. I mean,
I can provide documentation proof.
haven't seen it, so I'll object to it.
131 pages of text messages.
All right, Mr. Coker, is there somebody there assisting you?
My wife.
All right, she's not allowed to address the court. You're
She's not addressing the court.
All right, well, she needs to refrain from speaking during the proceedings.
Yes, sir.
All right, what documentation?
I have text message proof of transactions, dropping Beckett off, picking Beckett up between her and myself, and her and my wife.
All right, how come you haven't provided this information? This hearing's been set for a number of months now.
I didn't even know that the hearing last time, like I was told by Deborah Thompson that the hearing that was supposed to happen last time was postponed. unbeknownst to me, she came and agreed to things that I had never agreed to. I'm actually in the midst of talking to the Kansas Bar Association about Miss Thompson. She has flat out lied on my behalf.
Judge, I had an opportunity to just message my client directly. And her statement to me is that the parties did not consistently live together for the first 3 years of Beckett's life. That they were on again, off again. So I don't believe that that statement is accurate. Beyond that, Miss Ricky always was the one to provide insurance for Beckett, childcare for Beckett, and provide those basic financial needs for him, which, as this court is aware, would justify her receiving child support from Mr. Coker.
All right, thank you, Ms. Henry. You all will give me just a second. I'm going back through some pieces of the file here. Mr. Coker, you had said something about 50-50 parenting time.
Yes.
Can you clarify what that
If
statement was?
From Wednesday, the schedule used to be when we had him Wednesday, Thursday, Friday, every other Saturday, Sunday. In 2022, that changed by Deambra, and we had him every other Thursday, Friday, or every Thursday, Friday, every other Saturday, Sunday. So we lost Wednesday. Up until 2 years ago, we had him on that schedule with no problem until I took Beckett to Kansas City for his birthday for a baseball game. That's what started this whole court case. She did not appreciate that, and here we are today, 2 years later.
What time period was it you said you were exercising that parenting plan?
That I don't know the dates exactly. I'm going to say 2017 or 18 to 22. Maybe as early as 16.
All right, Ms. Henry, how would you respond to that statement?
Judge, my client would disagree that he had Wednesday to Saturday and every other Saturday until Sunday from 2017 to 2022. I mean, he had, Mr. Coker had DUIs during that time period. He served jail time during that time period. My client acknowledges that at least the year or two before we filed the paternity action, they were doing Thursday after school or afternoon time in the summer until Saturday, sometime early afternoon, and then every other Saturday until Sunday, which is not shared parenting time. My client had primary residential custody. So, I mean, we acknowledge that for the last year or two before we filed the paternity action, that was his schedule. But that is still primary with Ms. Ricky, and that prior to that, the schedule was inconsistent.
Very well. All right, Mr. Coker, anything else regarding?
Yeah, I've submitted to Eric Kidwell 131 pages and 13 character witnesses in reference to prove that was our time frame before all this.
All right, well, Mr. Kidwell is no longer representing you.
For a reason.
So anything additional?
I could submit him to the court, and I did not have any DUIs or jail time during that time.
Well, it's a little too late to submit them now. We're 20 minutes into a hearing.
Judge, I would only point out to the court, I have listed the maximum amount of support. I think that Kansas Child Support Guidelines gives the court wide difference as far as the judgment amount dating back to birth. Certainly understand that the court may not order that entire amount. Just want to give the court consideration for that. My client wants this finalized today, so whatever the court wants to do as far as that amount, and going down from that, we give the court complete discretion. Just want the court to be aware of the timeline and as far as what the dollar amount could be. Thank you.
All right, thank you, Ms. Henry. All right, I need to review. I've just now been provided the child support worksheets that were submitted. I need to review those and a couple other things. So I'm going to take about a 10-minute recess to give me an opportunity to look those over and go back through the file and look at a couple of things. So we'll reconvene around 4 o'clock. So we'll be in recess.
Thank you, Judge.
Thank you.
All right, we'll go back on the record. Let the record reflect the same appearances as before. I realize you all want to get some finality to this, but I frankly need additional time to go back through everything. This is a large amount of support being requested. I'm going to take the matter under advisement for about 30 days to give me time to review everything in more detail. Angela, can we get a date about 30 days out? We can do it by Zoom again, about a 30-minute window.
July 29 at 9. I can do that.
Does that date work for you, Mr. Coker?
Yes, Your Honor.
All right, so July 29th at 9 o'clock. I'll issue a ruling by Zoom.
Judge, I would I know the court's going to look at the court file, but just so the court has a frame of reference, I verified while we were on the break that Mr. Coker has never filed a domestic relations affidavit. And in fact, the court ordered at our hearing with the order filed on January 25th of 2023. At that time, that Mr. Coker had not provided any income verification, and the income verification was supposed to have been exchanged. I provided income verification that day. Mr. Coker was not present, but Mr. Kidwell was. And then I resubmitted it again in April of that year, and I have an email verifying that. And asked Mr. Kidwell to provide documentation because as of April, I still hadn't received anything from Mr. Coker, and never received a response. So I have never seen any documentation from Mr. Coker regarding income, child support worksheets, or DRA. So just so the court has that reference point in the court file.
All right, thank you, Ms. Henry. Anything additional, Mr. Coker?
Yes, I'd be happy to send over the email that I sent over to Eric Kidwell when I was asked to do that back in April, as well as any other pages that the court needs that I've documented with the domestic conciliar that obviously weren't turned in either.
Well, right now I'm operating with the information currently in the court file and what's been argued here today. So
I don't have any option to submit my paperwork because my past attorneys did not do their jobs.
if you wish to submit paperwork to Miss Henry, that's up to you.
Okay.
But I'm gonna go back over everything and I'll have a ruling ready for you all July 29th at 9 o'clock.
Thank you,
Thank
Judge.
All right, if there's nothing further, we'll be in recess. Thank you. All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled BBK, minor child by and through natural mother and next friend, Deamber Ricky versus Grant Coker, case number 22 DM 371. Petitioner Deamber Ricky appears in person with counsel Rebecca Henry. Respondent Grant Coker appears in person, pro se. We were last before the court June 18th of this year, at which time we took up argument on child support dating back to birth. I did take that matter under advisement as I needed time to go back through the file. I wanted to review some statutes and case law, which I did have an opportunity to do, and I am prepared to make a ruling at this time. KSA 23-2215 gives the court authority to order judgment for child support dating back to birth. There was argument during the course of that hearing on June 18th as to times that Mr. Coker may have been residing with Miss Ricky in the early periods of the minor child's life, who I believe is 13 at this time. We've already established a temporary order that's already in place, but this is to go back to birth. And after hearing the arguments that were put forth back on June 18th, what the court will do is award back child support starting at the age of 4 for the minor child. The evidence was unclear to the court, or the timeline during that first 3 years of the minor child's life. It's pretty established from what the court heard that while Mr. Coker did exercise parenting time, at least from 2017 to 2022, that was at most 3 days a week, which would still require him to pay child support according to the child support guidelines. The amount of support starting at age 4 will be pursuant to the guidelines based on the income numbers that were submitted, Ms. Henry, in your child support worksheet. There's never been a DRA filed by the respondent, nor had any of those income numbers ever been contested in the couple of years we've been litigating this case. So just to be clear, the back child support will start at age 4 to fill in the gap between the period of child support that the court's already ordered.
Judge, I do have I guess a request for the court to admonish of Mr. Coker. I received a phone call from his former employer, Brock LLC, which was the figures that I was using for the current child support worksheet and the figures that the court has just ordered be used for prior child support worksheets. After the last hearing, they contacted me to let me know that they were no longer going to be able to deduct child support from his paycheck per the income withholding order because he's no longer employed at Brock. So I would ask the court to admonish Mr. Coker to provide today verification of where he is employed, if anywhere, so that I may issue a new income withholding order for both this new arrearage that's going to have to be addressed and for the current support.
All right, Mr. Coker, where are you currently employed?
I'm not employed right now.
All right, how long have you been unemployed?
About 3 weeks.
All right, well, I will order that you provide income information, excuse me, employment and income information to Ms. Henry upon gaining employment.
And
Right.
Judge, just for the record, it's my understanding that Mr. Coker voluntarily left his employer. He
No, I
quit
was
showing up.
terminated.
He quit showing up at work.
No,
So
I was
anyways,
terminated.
All right, one at a time, please.
so
Mr.
just so
Coker, I'll
the
allow you to respond.
just so the court knows in case, I mean, because I know we're setting child support now at an imputed figure. But just so the court's aware of that. And if Mr. Coker decides to file any sort of motion, I certainly can provide more evidence and testimony from that employer to verify what I've reported to the court today. That's all.
Mr. Coker, do you wish to respond?
Yes, number one, it's impossible for me to show up to work because I work from home. So I'm always at work. Number two, I was terminated. I got a letter of termination. Happy to share it with court, with Ms. Henry, with whoever needs to see it. I was terminated. Not, I left.
All right, thank you, Mr. Coker. Ms. Henry, I'll task you with submitting the appropriate journal entry and worksheets consistent with the court's orders. Is there anything else we need to do today? Ms.
I would
Henry?
like to address the fact that we are taking Beckett again to Kansas City for the Royals Red Sox game. Need that to be on record that she has given permission for us to take him for Tuesday and Wednesday, the 6th and 7th.
Okay, I wasn't aware of anything being in front of the court regarding that issue. Is that an issue?
It always had. That's the reason why we're here today, is because 2 years ago, this is what happened. I just want it to be said by the court that she has given permission to go the 6th and the 7th to Kansas City.
Am I
Judge,
able to speak or?
Well, this isn't something that I was prepared to address today. I believe there's already orders in place regarding the parenting time.
There is, Judge, and Mr. Coker hasn't communicated anything to me regarding a visit to Kansas City. I think that's something that we probably don't need to take up the court's time for. We can communicate that among ourselves. But I know, the hearing today was a review on child support, so custody and parenting time issues are not before the court.
All right. Yeah, I'm not going to address it today. If it needs to be addressed, it can be brought by way of a motion. So, all right, anything else? All right, if there's nothing further, we'll be in recess. Have a good day.
Thank you.
What's wrong with this fucking books?